Yo, it's JP. Let's talk about appeals, okay? We're going to stick in the plaintiff side, employment discrimination, retaliation, sexual harassment, sexual assault. We're going to stay in that particular arena. So the first thing that folks have to understand is there are many levels to the process. You have, in some instances, an EEOC charge. You file a lawsuit in court. You litigate the case in court. And sometimes you have to go to a higher court. You have to go to an appellate court to correct the errors that the district court or the trial court makes. The trial court, that's the court where you file a lawsuit. That's the court where your case is originally filed. That's where you file your complaint. That's where the litigation takes place. It's in a trial court, okay? Unfortunately, over the past 30 years, federal courts have been granting summary judgment, giving it out like it was candy, okay? We just have to be real about this, folks. We have to be real about it, and we have to start calling it what it is. Okay, this is judicial activism. For 30, 40 years, federal courts have been singling out discrimination cases, in particular, discrimination, retaliation, sexual harassment. They have been singling out these cases, and they have been ignoring the real rules and creating these special rules that only apply to discrimination, retaliation, claims of that nature. So, as I have said many, many times on this channel, the real rule for deciding what makes it to summary judgment is Federal Rule of Civil Procedure number 56, FRCP 56. The federal rule governing summary judgment makes it crystal clear that summary judgment is only to be granted where there are no material facts in dispute. So the record is so clear, so overwhelmingly one-sided, that there is nothing left to debate. There's nothing left in doubt. All of the significant issues are resolved in favor of one side or the other. And then summary judgment is granted. And the plaintiff in these cases almost never gets summary judgment on anything. But the defendant, okay? Corporate America shows up in court, and in these types of cases, discrimination, retaliation, federal courts, they have basically recast Rule 56. Not even recast it. They've thrown Rule 56 out the door. Okay, they threw it out the window. Okay, and they basically say, here's what they're really saying. They don't say this in their orders, but here's what they're really saying. We don't think discrimination is a real claim. We don't think it's a real thing. I mean, we know the law says you can bring a claim, but I don't like it. Because of my politics, because of my biases, because of my personal philosophies, I don't like you bringing a discrimination claim. And because I am the judge, because I am basically like the king, I'm going to grant summary judgment in your case and dare you to do something about it. Because these judges, right? These judges know, they absolutely know what Rule 56 says. They absolutely know what Rule 56 says. They know what it says. They know what it means. They know what they're supposed to do. But because of their personal biases and philosophies and political leanings, they grant summary judgment in employment discrimination cases. They make up extra hoops that you have to jump through. Look at this whole McDonnell Douglas thing. If you're in one of these cases, you'll see this case called McDonnell Douglas, okay? McDonnell Douglas. Corporate America made this up. And the federal courts and the Supreme Court, they all bid on it. They say, yeah, that makes a lot of sense. Oh, we're going to do it that way, right? So McDonnell Douglas was the whole, you can't prove a discrimination case unless you have a comparator, okay? So first, you got to get somebody who's similarly situated, and you got to show you were treated differently than them, and then the company can come up with a legitimate, non-discriminatory reason for firing you, and then you can rebut that, but you can only show pretext, right? Courts were taking Rule 56. Rule 56 is a simple, straightforward test. It is, if this case goes to a jury, could a jury reasonably rule in favor of the plaintiff? Or if the case goes to a bench trial in front of the judge, could I reasonably rule in favor of the plaintiff? Is it so clear? Is the record so clear, so overwhelming, one way or the other, and only ever in favor of corporate America? Is the record so clear that I can say, as a matter of absolute fact, there is no discrimination here. There's no retaliation here. That was not the reason. That was not the cause. There's not even a shred of doubt, right? That's what the standard is supposed to be. But courts say, oh, you got to do your McDonnell Douglas, you got to get your comparator, and then they got their legitimate reason, and then you got to rebut that. And I don't think you jump through all these hoops. But the federal rules were never about creating flipping hoops, right? The emperor has no clothes, people. America's legal system in 2025 is a full-blown corporate welfare system. Are there exceptions? Sure, there are exceptions. Sure, there are exceptions. There are some judges who actually apply and follow the law and do so in a fair, unbiased, and impartial way. But better than 50% of the time, you have judges who grant summary judgment in these cases without following Rule 56, without following the law. And they do that because of their own personal biases and prejudices and philosophies. And the appellate courts, unfortunately, this is the problem of sort of the old-timiness, right? When I talk about the old-timey, the folksy, good old boy network, right? The you scratch my back and I'll scratch yours, and we're never going to say anything bad about each other, right? That's law is like the mafia, okay? And everybody in law acts like they took this omerta, right? They took this blood oath never to speak badly about other lawyers, right? And some states, like Florida, for instance, some states have codified this into their legal regulations where you're not allowed to speak badly about another lawyer. Well, that blatantly violates the First Amendment, okay? Because truth is an absolute defense to all of this. And there are plenty of things you can say. Like, for instance, what if I said, there's this lawyer in Miami, who runs a 30-lawyer shop, and he's having sex with his paralegals and associates and harassing the receptionist and sending around pictures of his junk, and the guy's totally out of control. What, I'm not allowed to say that? You're going to tell me I'm not allowed to talk about that? Okay, friendo? In this country, in America, we still have rights. You can't have my rights. I'm still using them. You can't have my rights. I'm still using them. Thank you. But so one of the tools of the power structure of hegemony, okay, is keeping people quiet. You keep people in this folksy, old-timey, muckety-muck cesspool where you make it clear you can't never speak no bad words about each other because we're all on the take. We're all in this dirty nonsense together. You telling me, I'll tell on you, right? But I'm clean. And I'll tell you, like, there's 6 million other things I can go do with my life. I got other businesses, okay? Why am I in this? Why do I do this? Why do I deal with all of this unmitigated nonsense every day? Because I'm a true believer and because somebody's got to do it, okay? The system is so dirty. The system is so corrupt. One of the things you're seeing in terms of American society right now, right, where you're seeing people just violently lash out against the system, that's because the system is so dirty and so cooked, right? Like, America is in for some wild times over the next 10 years, okay? But the appellate courts almost never get real about trial court judicial activism, okay? The appellate courts almost never say, Rule 56, clear as day, and the judge's ruling in this case is beyond the pale. It makes no sense. You're rejecting many of the facts the plaintiff has put forward. You're drawing inferences in favor of the defendant. Like, this is judicial activism and clear bias. Go back to the beginning and start over and don't do this again because you're embarrassing us. No appellate courts ever say that. Well, they should. Well, they should. And so when you get into cases like this, you have to understand that you might have a very real case. And that's a problem. That's a problem for a lot of you, okay? It's a problem for a lot of you because so many of you think you have a real case. You don't have a real case. You don't have a real case. I get 300, 400, 500 of these a week, okay? Maybe 5% of people have a real case. Maybe 5% of people have a real case. Maybe 3% have a case that I think is strong enough to pursue because, most of our work is in Florida, which is the Deep South, which is the old Confederacy, which still has historical echoes and ties to that. And it is uphill sledding. It is uphill sledding. Even in cases that are strong cases, that are compelling cases, where I look at the case and say, wow, this case is a banger. Florida, right? Probably going to get summary judgment in. Probably got to take an appeal. Okay? And that's what this is about. That's what this is about. You can have a very strong case and need to take an appeal. And that's not because you don't have a case. Let's start right there, okay? If a court grants summary judgment against you in an employment discrimination, retaliation, sexual harassment, hostile work environment case, you might have no case, but then again, you might have a very strong case. A federal court granting summary judgment in an employment discrimination, retaliation, etc. case doesn't mean anything. You cannot interpret that as an objective evaluation of the strength of your case or claims because there is so much rampant judicial activism in the federal courts, particularly when it comes to employment discrimination, retaliation, etc. I give you the best benchmark, the best test, the best barometer of that, okay? Look at it when the company is the plaintiff, right? Instead of the individual being the plaintiff and bringing a case for discrimination, retaliation, etc., suppose the company is the plaintiff and bringing a case for breach of a non-compete agreement or theft of trade secrets. Well, boy howdy, courts are giving out injunctions like candy, and they are so hesitant to grant summary judgment in those types of cases. It's almost as if there's rules for thee and me, but not rules for our corporate overlords. It really is almost like that. And so you can't interpret the grant of summary judgment in an employment discrimination case as having any real validity or meaning. It has to be scrutinized. You have to scrutinize the record. Now, the problem is for a lot of folks, economic realities, okay? The economic realities. For a lawyer to pursue these types of cases, especially in the American South, and we can get into that, okay? The reason why the American South, the Confederacy, that's all still alive and kicking, okay? It's a whole ideology. It's historical. It's in the ether. It's in the water. It's in the culture, okay? The Deep South is still Dixie. It's still the Confederacy, and Florida is a core part of the Confederacy. In fact, you asked me today, what is the heartbed, right, of the Confederacy, right? Well, probably Florida, Texas, maybe one or two other places are going to be as central in terms of being Confederate actors in American society. But Florida is truly the modern American Confederacy slave state for many, many reasons. I've talked about that for years with the non-compete abuse and everything else. But the economic realities, especially in the South, you have these courts granting summary judgment, just giving it out like candy, okay? And so a lawyer that puts this time and this effort into these cases, you have the huge risk of summary judgment, but then at the same time, you have federal courts going out of their way to whack down the fees that plaintiff side employment lawyers can charge. And this all goes back to a 2010 Supreme Court case. I believe it was Purdue and Justice Alito, right? Justice Alito of the flying his upside down trader flag outside of his beach house and saying, that was my wife, I can't control my wife, you know me. But yes, Judge Alito gave us this wonderful decision in which he basically laughed at public interests, plaintiff side employment lawyers, etc., and said we can't possibly be giving these folks $800 an hour because that's what we give to the lawyers at the biggest and best and most prestigious firms in America, right? We can't possibly be giving them a a multiplier or a bump or a boost or a +1 on their fees, because, this is what we pay to folks from the biggest law firms, the prestigious Wall Street firms. We can't possibly be paying civil rights lawyers the same as we would pay these people. Oh, but yes, you could. You could if you were operating consistent with the purpose, the premise, and the goal of the civil rights legislature going back to the Civil Rights Act of 1866. You could do that. Might have been 1865. Sometimes I get it mixed up. 1865, 1866. Post-Civil War, original Civil Rights Act. I think it was 1865. Because the purpose of that law and the purpose of the civil rights law, right? It has to be read broadly, remedial purpose, right? Level the playing field, equality, equal opportunity, right? And if you wanted to incentivize lawyers to take hard cases, especially in the Deep South, then you would grant them a significant fee in the cases where they prevail, but the courts don't. And why do the courts not do that? Well, the courts don't do that, obviously, because they want to disincentivize lawyers from pursuing civil rights cases against the system. And this is why I say that the vast majority of the American legal system has simply become a corporate welfare system, and it's simply an arm of the corporate power structure in America. And it is just systematically going through all of the tools, right, that were once available and eliminating any tools that existed to fight back against it. And yet here I am still fighting. So you might have to take an appeal. But the reality is most lawyers are not going to be willing to take an appeal, and you can't fault them. Because they might have a year, they might have a two years in the case, then another year on the appeal. They got $10,000, $15,000, $20,000 in costs. These are big investments and expenditures of time and money. You can't fault the lawyers for not taking an appeal in your case. But on the front end, if you have a strong case, if you have a very strong case, you should find out from your lawyer, from your law firm, from your representation, whether or not they pursue appeals, because some plaintiff side employment lawyers simply do not pursue any appellate cases. You lose in the trial court, that's it, they're done. Others are willing to go to the next level. They're willing to go to the appellate court, okay? And practicing in the trial court is very different than practicing in the appellate court. I think there are relatively few plaintiff side employment lawyers in the South who are willing to do both levels. Our firm is willing to do both, right? Like if we have a case, if we take the case through the trial court process, we believe in the case, we go to summary judgment and we lose and we feel like we should not have lost, we are going to appeal. Now that's tough because the defendant in these cases will often get what's called a cost judgment. They'll get a judgment for their court costs, which are things like deposition transcripts and filing fees, things like that. It's like $5,000-$6,000. And then as soon as they get that, they'll threaten to garnish my client's wages. They're very modest wages. These are a lot of times these are working people. These are poor people. And you get a company threatening to come after them and garnish their wages over $5,000 or $6,000. Then we have to post a bond to prevent that from happening, which has to come out of my pocket, right? But I just can't let them do folks like this. Those who can must, Those who can, those who have the tools, those who have the ability, those who have the mentality, those who have the strength, those who have the fortitude, those who have the resources, those who can must. So if you get into something like this, if you get into a case, plaintiff side employment discrimination, retaliation, etc., and you're looking at your lawyer, considering different lawyers, well, first of all, I don't represent anybody who shops me, okay? Like sometimes people call and they're like, I'm evaluating different lawyers, and I'm like, good luck with that. Good, you go. Good luck with that, right? They don't know. They don't understand. Anybody who is shopping our firm against other lawyers and law firms, they have zero clue what's up. And also a lot of these folks are impatient, right? Where they don't understand. The only thing is you have to make sure if you need to file a charge with the EOC, that has to be done. And if you have a right to sue, then that has to be done within 90 days. But there's so many other aspects of this where there's plenty of time. Nobody needs to be impatient. Folks could sit back and patiently let me work on stuff, let my team work on stuff. But, expecting people to be patient in the modern world, where they got Amazon next day delivery and instant gratification, you know, that's almost like asking too much. But the bottom line is, you might have a very strong case. You might lose in the trial court for the reasons that I just laid out in this video. And then you might need to take an appeal, and it might be another year in your case. But in order for you to have that even as an option, you need to speak with your lawyer on the front end and find out whether or not, if they believe the case is strong, whether or not that they would be willing to appeal it, or at least consider an appeal. Because otherwise, if you lose a case in a trial court with a law firm that's not willing to appeal, even if it's a strong case, then you're probably dead in the water. Because at that point in time, getting another lawyer to come in who has not been involved in the case and to take it from stage one for the appeal, learn the entire record, go through everything, learn the case, invest all that time, that's much different than a lawyer who's had the case the whole way along for a year and a half. Now they lose at summary judgment, but they know the entire record. They've already done summary judgment briefing. They already know the facts, and they can do an appeal. It's going to take some work. It's going to take some time and some money, but that's much different than a new lawyer taking over the case and coming in. So always check with whoever's going to represent you in a trial court case. Always check about whether or not they even do appeals, and if they might be able to represent you in an appeal if you lose in the trial court. Because even in strong cases, especially in the South, that is a very realistic possibility. JP, thanks for watching. Have a good weekend.